So good afternoon, everyone. Great pleasure to welcome you to another webinar within the context of our War Crimes Research Group series here at the Department of War Studies. My name is Maria Varaki. I'm teaching international law at the Department of War Studies. And today I'm particularly happy and very grateful to a friend and a great scholar of international criminal law, Professor Patrycja Grzebyk. Sorry, I didn't say that properly. I apologize for that. Patrycja, who today is going to talk about a very, very interesting and very timely, I would say, topic about the challenges regarding the prosecution of the crime of aggression. Patrycja is the expert, one of the experts on the crime of aggression, with extensive writing about that, but also with participation. And she's going to the Assembly of State Parties. So she's going to talk to us about three current developments that take place, if I'm correct, Patrycja, the last months, as you already described in your what you're going to talk about that. But I would like to say also that Patrycja is an associate professor of international law at the University of Warsaw, and she's one of the editorial members of the European Society, one of the board members of the European Society of International Law. She's in charge of the ASIL Reflections, as I say, has written at least 4 books regarding international criminal law, and not only. Patrycja, you are a member also of the Moscow mechanism of the OECD. You are a member of many organizations. You're a member of a committee, one of the committees of the International Law Association. And what can I say? We're very lucky because today we have you with us, and we are looking forward to your comments, your observations, and your insight about the crime of aggression and the politics surrounding the crime of aggression. Having said that, you have the floor. Thank you very much for accepting our invitation. Thank you.
Thank you very much. Just to check with you once again, do you see my presentation now?
Yes, we do.
Okay,
we do.
Perfectly. So yes, the crime of aggression is very specific crime because this is the crime which from the very beginning had very much in common with the politics. It starts with the politics because, the prosecution of the crime of aggression, the precedent in Nuremberg and Tokyo, this was the political decision, yes, that there was no specific rules which would criminalize aggression as such. To begin hostilities, to start the aggression was considered as one of the prerogatives of every state. And the idea that we need to prosecute Nazi Germany and Japan for the crime against peace, this was political decision, that it was believed that maybe we don't have clear legal rules, but because of the needs of the justice, we need to start to prosecute for the war of aggression, which was started by Germany and Japan. And you can see on the screen now this excerpt from the International Military Tribunal Charter, when there was reference to the crimes against peace, and this crime was mentioned on the first place, considered as the most important one. And indeed, the main prosecutor, Robert Jackson, really focused in its investigation, in its accusation on this crime. The focus was so high that in Tokyo, the decision was taken that only those who can be prosecuted for a crime against peace should be accused in this tribunal. So this is sometimes very much criticized because other war crimes or crimes against humanity were to some extent neglected, as so much focus was devoted to the crime against peace. So the crime of aggression. But you can see from this excerpt that we didn't have a clear definition what is a war of aggression. When the main prosecutor, Robert Jackson, was asked about it, he said there is no need to clarify anything, because if you have doubts, just read the dictionary, and everybody knows what is a war of aggression. This is exactly what Germany started. But when we wanted to apply the same rules, those Nuremberg principles, to all states in the world, then it started to be much more difficult. And just to tell you that when the International Law Commission started to discuss the idea of the permanent International Criminal Court at the end of the 40s, they decided that first we need to start with the new criminal code, International Criminal Code, and then the decision was taken, so let's start with the most important crime of aggression. And the works on the definition of aggression lasted till 1974, and only in 1996 the Code of Crimes Against Peace and Security of Mankind was adopted and did mention the crime of aggression. So you could ask yourself why the aggression was so difficult to define it, to prosecute it after Nuremberg and Tokyo. And we have certain problems which are coming back, which will not end, and we need to take them into account, that this is a kind of inherent future of this crime. So firstly, to talk about crime of aggression, first we need to state that there is aggression committed by a state. So we need to blame one state for starting the aggression. And this is already very much controversial, because this means that we must assess that certain use of force by a state is completely unlawful and should be considered as a crime of aggression. And usually states, they never start the war with the words, yes, we do commit aggression. Usually those states, they justify their use of force. And sometimes they are really convinced that they are doing this for the right purposes, or at least they want to sell this story to the public opinion. So that's why many scholars, they were saying, well, crime of aggression is very unique because always you need to blame some state for being behind the aggression. So that's why this crime is very much politicized. Then the problem is that aggression should be the certain examples of unlawful use of force. But we have very blurred contours of what is lawful and what is unlawful. Of course, if we read the Charter, UN Charter, when we read the letter, it should be understood, properly. But we know that states introduced many new exceptions. They introduced many new justifications. Just to let you know, for example, the whole discussion about the possibility to intervene in another state to fight with the non-state actor, or, for example, the situations when states were using force allegedly to defend their own citizens. All those examples were at first considered as illegal, but then justified by states and at the end accepted to great extent by the international community. Another problem is that the crime of aggression was always crime of leaders. And if we talk about leaders, then definitely the problem of immunities would appear, because usually we will talk about Troika, but not only Troika, also other high officials, they would try to benefit from the immunities and privileges, and we need to deal with this problem somehow, whether we respect those immunities or not. Of course, aggression is linked with the problem of the peace and security, and then the prerogatives of the Security Council appear, because Security Council wants to have this monopoly for statement whether aggression was or was not committed. But at the same time, we need to remember that Security Council avoids usually the use of the notion aggression, act of aggression. Security Council usually prefers to speak about threat to peace, because if you use a notion of the act of aggression, then you need to put a blame on one of the state, which makes your negotiations less flexible. So that's why Security Council permanent members, they are extremely reluctant to give to any tribunal, to any other organ, the possibility to state anything about aggression. Also, We could observe it from the Nuremberg that sometimes if you are too much focused on the crime of aggression, you could be distracted from the prosecution of other core crimes, and also you need to devote certain resources to investigate this crime, which is not easy, which is very demanding, and that's why sometimes it is raised that maybe it's not worth doing, that perhaps we should focus on those other crimes, but not on the crime of aggression. Of course, this argument could be criticized by the fact that the aggression is usually a source of other crimes. So maybe we should really prevent the source and not only the effects of the aggression. Also, one of the challenges and problems which are raised is how we will collect the evidence for aggression. Because usually, if you want to talk about crime of aggression, we are talking about the security issues. And usually those documents related with the security of the states, they are not relieved, they are not publicly available. And then if you ask for those kind of documents, usually the states would decline. That they would say, I'm sorry, I cannot share them. This is too fragile. This is top secret. We don't want to provide you with this evidence. But this means that it's really impossible to prove guilt beyond a reasonable doubt, or, for example, rights of the accused cannot be entirely respected if we do not have access to all the documentation. And of course, I am aware of all these problems. However, we have also tools to address them if we are convinced that crime of aggression should be prosecuted. And this question were also asked when the Rome Statute was negotiated, and there was a really huge odyssey concerning introduction of the crime of aggression to the Rome Statute, but at the same time, this odyssey didn't end. So firstly, in 1998, there was a discussion whether crime of aggression should be introduced into the Rome Statute. The decision was taken, yes, but we don't have a good definition. So let's hold the place for the crime of aggression, but we will prosecute this crime only if we agree on the definition. And this definition was adopted in 2010 after long and difficult negotiations. The funny thing was that the crime of aggression still relies on the definition of aggression adopted by the General Assembly in 1974, even if in 1998 some states were arguing that no, this definition must be changed, we need to figure out something else. And then in 2010, we were left exactly with the same definition. However, what is interesting, we are in 2010 and still some states are afraid of triggering, of opening this jurisdiction of the ICC over the crime of aggression. So that's why decision was taken that the decision on the activation can be taken only in 2017. And this decision was taken on 2017, which means that the court's jurisdiction over the crime of aggression was activated on 17 July 2018. This is a very important date because it also means that from this date, this is the court which became the master of the interpretation of amendments. We have various doubts how some amendments should be interpreted, how this jurisdiction should be exercised in certain situations. So we need to be aware now that this is not left to the states, but now this is the court which could decide about this. And then there are certain limitations of this jurisdiction of the ICC, and that's why there was a huge attempt made in July 2025 to amend amendments. It didn't went well, although I think that there are some reasons to be optimistic. So far, even if this jurisdiction of the ICC over the crime of aggression was activated in 2018, so far we didn't have any proceedings concerning crime of aggression in the ICC. Why? Because of the very specific limitations and conditions. When you look at the Kampala amendments, and I'm not focusing now on the definition, but only on those jurisdictional issues, you will see that this jurisdiction is completely different from the jurisdiction which we know for the war crimes, genocide, or crime against humanity. Because in the case of war crimes, crimes against humanity, or genocide, the idea is that every time when this crime is committed on the territory of the state party or by the citizen of the state party, or when there is a referral by the Security Council, the court has the jurisdiction. In case of the crime of aggression, it works differently. Well, firstly, it was stressed that we need to have at least 30 ratifications from state parties. This was additional condition put there because in case of other amendments to other crimes, you don't have this kind of limitations. However, this was a kind of condition, but this condition was fulfilled in 2017. Then there was this decision about activation achieved because in 2017, states decided to activate the jurisdiction of the ICC. And it's not top secret to reveal that the main powers behind the delay of the activation and to limit the jurisdiction of the ICC at that time, these were France and UK, so the permanent members of the Security Council. And then the condition is that when you read paragraph 4 and paragraph 5, you will see that in case of the state which is not party to the statute, the court shall not exercise the jurisdiction at all. Yeah, that's why, for example, when Ukraine recognized the jurisdiction of the ICC, the court could prosecute crimes against humanity, war crimes, and genocide, but it could not, even when Ukraine became the party to the Rome Statute and ratified amendments, the court could not prosecute crime of aggression committed on the territory of Ukraine because Russia is a not party to the Rome Statute. In addition, there was a possibility to submit a special declarations based on which you could ratify amendments and at the same time opt out from the jurisdiction of the ICC. And additional conditions were that the prosecutor needs to first go to the Security Council and ask for the determination of the situation. However, if the Security Council will be blocked, which is quite common, then after 6 months, prosecutor can proceed. And at that time, in 2010, some states were very much concerned that maybe 6 months is too long. However, now when we know that the proceedings in the ICC last really, really long, those 6 months looks like a very speedy procedure. So why still politics matter so much in the case of the ICC? The Rome Statute was adopted in 1998, and there were some developments which we cannot neglect. 2001, the attack on the World Trade Center, on Pentagon in US, and the fact of the changes in the law on use force, that the right to self-defense was expanded also to cover the possibility to attack non-state actors on territory of another state. That there was a claim on behalf of the Western states that they have right to intervene in other states to change the regime. The infamous intervention in Iraq 2003. And this is the moment which I think it's not much appreciated in Western Europe, how this intervention in 2003 really damaged the picture of the Western powers. Also, I must say that Poland also participated in this intervention. And that's why now, when we are stressing the need to, for example, support Ukraine, we often hear, what about Iraq? What did you do in Iraq? You just apply double standards. And this is the issue which is coming back all the time when we discuss how the ICC works, the double standards. 2014, annexation of Crimea. And please have in mind that in 2014 and in 2022, President Putin presented a whole list of justification of the use of force against Ukraine. So, of course, Russia didn't admit that they committed aggression, but they claimed that they acted in a justified manner. And that's why the intervention is completely lawful and should not be treated as a crime of aggression as such. But this also provoked a discussion because for some states, this expansion of the jurisdiction of the ICC was very important in particular context, the context of Russian aggression. Of course, ongoing discussions about Security Council prerogatives. You could hear about the talks about the reform of the Security Council during the last year summit. There was the German initiative, which was talking about the necessary changes within the Security Council, about the geographic expansion of the permanent members, or to secure some positions for Africa, for other regions, and also ongoing discussion about veto power. And then this crime of aggression discussion and whether other organs should talk about aggression or should assess the situation as aggression, of course, is coming back. And the decisions about arrest warrants. 2023, we have arrest warrant against Putin, which was quite well received, even if it was quite surprising that the ICC decided to issue arrest warrant against incumbent head of the state, because we know that those proceedings against the incumbent officials, they are not going very well. We remember how the proceedings against Kenyatta, president of Kenya, ended. And we know that usually we just need to wait for the person to stop being in the position just to be able to really proceed with the investigation and with the accusation. Okay, so then I think that the more damaging was Netanyahu arrest warrant in 2024, also in very specific context, because the conflict in Gaza also raised questions about who is aggressor and whether anyone on one side or on another side should also be prosecuted for aggression as such. So the conflict in Palestine, which was always very much complicated, also raised additional doubts. But this arrest warrant against Netanyahu also started the whole campaign of sanctions by United States. The Trump administration imposed sanctions concerning particular judges, but now we have the problem that there is a threat of institutional sanctions, which could be really an existential threat to the ICC. So this is all those arguments, all this politics was in the head of the states, which decided to work on the building the real possibilities to prosecute crime of aggression. And you need to look at those attempts to expand the possibilities and to strengthen the criminalization of aggression on various levels, which are simultaneous efforts. Firstly, the negotiations on the statute of the Special Tribunal for the Crime of Aggression against Ukraine, which lasted for over 2 years, and these were extremely difficult negotiations. Secondly, the works of the International Law Commission, which has in its agenda the topic immunity of state officials from foreign criminal jurisdiction. The special session of Assembly of States Parties, and also attempts in national courts to start to prosecute crime of aggression. So what about the special tribunal? This is the tribunal which we had to establish. As I explained to you just a few minutes ago, the ICC was not able to prosecute crime of aggression committed against Ukraine. So that's why the negotiations were ongoing, but then the problem appeared, okay, but some states like France, like US, like UK, they were extremely unwilling to give the possibility to prosecute Troika. But at the end of those negotiations, I think that the results are quite satisfying, because firstly, it was agreed that this tribunal would focus only on those who bear the greatest responsibility for the crime of aggression against Ukraine. So very much Nuremberg style wording. Also, the definition which was included in the statute is taken from the Rome Statute. And then also what was stressed is that functional immunities in principle should not be applied before the special tribunal. Very important also in the light of the discussions within the International Law Commission. However, those immunities are respected in case of troika. They don't say that they will never be prosecuted, but as long as they are on their positions, the investigations against them, the indictment against them must be suspended. Yeah, and of course, for some states, this was very disappointing, but I think this is very realistic approach to the situations which we have now in the world. What about those International Law Commission works? Well, this works last for a few years already. And what is particularly important for us is the fact that in 2017, there was a discussion which crimes cannot be covered by the immunity, by the material immunity. And there was no problem to put on this list genocide, war crimes, crimes against humanity. But one of the propositions was saying, please put there also crime of aggression. And there were many states which were against. And that's why at that time the vote had to be taken. And in the result of this vote, in 2017, crime of aggression was not included on this list. But then, as you know, when there is a draft presented by the International Law Commission, states may submit their comments, and many states, they stress that for them it's particularly important to have crime of aggression, and they also referred to various precedences in their own national jurisdiction. What was reminded was the fact that, for example, during World War II, Hitler was put on the list of criminals, and he was accused for his involvement in the crime against peace. So because of those discussions, because of those comments, because of this dialogue between Commission and the states, in 2025, in the new version of Article 7, crime of aggression was finally included. So this is quite huge achievement, which is a kind of candy which we received, having in mind the results of the special session of Assembly of States Parties of 2025. Because this special session, its aim was the so-called harmonization of the jurisdiction of the ICC. So the idea was that we should have exactly the same rules concerning the jurisdiction, no matter whether we talk about war crimes or, for example, crime of aggression. And why this effort had to be taken? Firstly, states were obliged to do it because this was the obligation put in the resolution from 2010. Secondly, many states, they were stressing that, of course, they are not naive. They don't believe that the expansion of the jurisdiction would really protect them against aggression. But at least it gives them another tool in their toolbox, how to strengthen their right to self-defense, how to better equip their organs in the fight against aggression. Many of them, they were stressing that if we do not criminalize crime of aggression, the prohibition of aggression rule is weakened, and we have the erosion of the legal order and rules concerning use of force. So the criminalization of the crime of aggression just helps us to strengthen our legal order. And also, this was the response to this narration about double standards. Because yes, we have now double standards, having in mind how very limited the jurisdiction of the ICC over the crime of aggression is, having in mind that we have 49 state parties to the amendments concerning crime of aggression. So with the expansion of the jurisdiction, we reduce selectivity, we fight with the double standards. And also, you could be convinced that many of those crimes which are committed during the war, they can be prosecuted somehow as war crimes or as genocide or as a crime against humanity. But not all the evil related with the aggression, because during the war, according to the international humanitarian law, it's completely lawful to kill enemy soldier. It's completely lawful to destroy military targets. But if you criminalize aggression, those losses are also included. You also emphasize that they are not allowed because of the other regimes which we have. And what was also stressed by those states which were engaged in the negotiations of the special tribunal for the crime of aggression against Ukraine, we just want to avoid additional costs with the establishment of the new tribunals which have to deal with the crime of aggression. If we have permanent tribunal, if we pay salaries for the judges, so why should we establish another institutions if we have perfectly prepared institution to deal with this crime? But there were also some arguments against harmonization, that this is not the best timing, having in mind all the sanctions, having in mind all the problems which ICC has, well, the problems with the main prosecutor and the alleged violations committed by him. Then also it was stressing that aggression is really unique crime, having in mind this political dimension related with aggression of the state. Also that maybe there is not much interest on behalf of the state, having in mind that less than 50 states ratified those amendments. But this is, this is, I think, very misleading, because for some states, they decided to not ratify those amendments because for them, those amendments are just too limited. It's not enough for them. They just expect the same treatment of the crime of aggression like other crimes. So that's why some states were really discouraged and they were really disappointed with the Kampala results. And this was the reason why they didn't want to ratify those amendments. Also, states were stressing the role of the Security Council, and this is the issue. Some of them, they are involved in the interventions in other states, and they were just afraid that their citizens could be prosecuted for crime of aggression because of the alleged illegal use of force. And additional concern, which was not maybe properly addressed, was the possibility to, if we expand the jurisdiction of the ICC, perhaps we could apply this jurisdiction retroactively, even till 2002, because if the crime of aggression was included already in the Rome Statute, then if we adopt new rules without any additional conditions, there was such a possibility that we could apply it even retroactively, even also to the crime of aggression committed against Ukraine. So what kind of dynamics we have now? They were, during the Assembly of States Parties, there were 5 states who were absolutely against the expansion of the jurisdiction of the ICC. These were Canada, France, Japan, New Zealand, and UK. They were also joined by other states which were not maybe so outspoken, but it was clear that for them they are against the expansion of the jurisdiction of the ICC. These were Argentina, Australia, Uganda, and United States. Some of the states, they decided on the tactics that they would stress the need of consensus. And these were, for example, Brazil and South Korea. And you need to take into account that the previous decisions about crime of aggression in Kampala, in New York, they were taken by consensus. But why they were taken by consensus? Because when there was the end of negotiations and there was a check how many states you have in the room, there was no quorum. So to call the vote would mean that maybe no decision would be taken at that time. And but also, if you emphasize consensus, it means that you give fuel to the opponents, because they can block anything by stressing the need of consensus. There was also a group of friends led by Germany, Liechtenstein, Switzerland, which were really pushing for harmonization. And I could really I could really observe how those, you would say, very general statements made through the whole day, they really managed to build the pressure that there is a need, that states see the problem. And this pressure really worked, because at certain moment, there was this for France or UK, the whole session could end with nothing, and this would be very satisfying result because they didn't want to have any harmonization. However, because of this pressure and because of this dialogue with other state parties, they decided that some compromise solution needs to be decided. And just also to reveal you some diplomatic work which was taken there, how those opponents managed to use different tricks to secure the result satisfying for them. The delay, the shortening of the sessions. In the past, it was that you could negotiate till the very late night with the stopped clocks. Yeah. However, this time, because of the financial crisis in the United Nations, we received the information that all the negotiations need to end each day at 6 p.m. This meant that we had very limited time. Yeah. And the other side knew about this. Also, all the time repeated the same questions, which were all the time answered, but the other side just ignored it and all the time repeated the same questions and tried to raise additional doubts. And those, these delays, this blackmailing that, okay, we can leave and then you will be left with nothing, or we will, for example, withdraw from the Rome Statute, because those kinds of threats were also expressed. These were very strong arguments because everybody was just afraid that at this moment when the ICC is so much attacked, we cannot afford for losing big players as the state parties to the Rome Statute. So what is the result of the special session? It was agreed that we will meet once again twice. Well, we will meet in 2027 at the intersessional meeting, but there will be a special session in 2029 in New York. It's important because usually you have more states present in New York than in The Hague. So also maybe I could reveal you that on the very first day of the special session this year, when the credentials was submitted and it was announced at the end of the first day how many credentials were submitted during the special session, it was clear that the group of friends doesn't have the majority to call the vote, to win the vote if the vote would be called. But to organize the special session next time in New York, it gives you a greater chance to have a better presence and to be prepared for the vote. And also it was stressed that, okay, it should be quite short, but, at least, no longer than 5 days. So probably 5 days would be left for the negotiations. So are we doomed? And I often repeat one of my favorite citations from The Lord of the Rings, when Gimli is saying, certainty of death, small chance of success. What are we waiting for? Well, we cannot wait. The crime of aggression is against the all of humankind. It is related with the suffering of the people. So this is the priority for every human being, to do what is possible to eliminate aggression as such. So of course that there are some steps forward and steps back. It's normal in the politics. However, we have some kind of roadmap which gives us hope that maybe in 2029 we would be able to expand the jurisdiction if the states understand the need. But in the meantime, we can observe the developments in national courts, because in national courts, the prosecution of the crime of aggression is ongoing. And we need to understand that if you are attacked, if you are living now in UK and UK is attacked, nobody would be able to explain to UK that, well, UK, you cannot prosecute your aggressor for the crime of aggression. Of course that UK would love to prosecute aggressor, but it's very important to understand that you can be a victim of aggression quite soon, and being in this position, you really would pressure to be able to prosecute crime of aggression. We can observe also the role of the civil society. Some states at certain moment of the negotiations were quite reluctant to talk about the further criminalization of the crime of aggression and expansion of the jurisdiction of the ICC. but because of the pressure of the civil society, especially in democratic states, of course, this attitude started to change. And what is very positive, we observed that certain human rights organizations, they started to think about crime of aggression as a kind of task for them. That crime of aggression is not only the politics of states which do not affect people, but crime of aggression is also violation of the right to life. So it should be a point of interest for the human rights organization. And of course, very important is the role of the ICC and in what way the ICC would go through different crises which are ongoing. But also I would like to stress that I don't remember any year when the ICC wouldn't be in the crisis. Always there was some crisis, you know. I remember the attempt to withdraw from the Rome Statute by the whole African Union. I also remember the scandals related with the previous prosecutors. So those crises which we have in the ICC now is of course serious, but we need to remember that there is always some kind of crisis in the ICC, and we manage somehow to survive. So what needs to be done? Clarify what needs to be clarified. We need to fight for the better level of ratifications. However, we need to understand that for some states, if they know that there would be a potential change in 2029 and the ratification process is quite long one and demanding, they would not feel a huge interest in going with the ratification now at this moment. So this is very tricky issue, and I'm not sure how we should handle it, because it's very difficult to convince a state to start the ratification process, not just to tell them, okay, you are ready with the ratification, so be prepared, because in the moment you would have to ratify something more. We need to be prepared for the voting. I know that consensus is a very nice thing, but you cannot be blackmailed by the rule on consensus. And also we need to be engaged in the dialogue with the underrepresented states among state parties to the amendments, because only few % of African states members are parties to the amendments. So now the focus is to really convince African, Asian states to really join the amendments. There is also, we could see that it's not that we will talk about mobilization for the New York session, but this really needs to be mobilization. It really needs that we need to check who would come, because we cannot be surprised by the announcement that there are too little, that we don't have enough number of states to go with the potential vote. And I think that very important is also how the activation of the works of the Special Tribunal concerning crime of aggression against Ukraine would go on, because this tribunal could have essential role to stress the prohibition to use force and to clarify certain rules concerning a crime of aggression. So I speeded because I just wanted to give you the chance also to ask me the questions if needed. So now I will stop, and I am at your hands to answer whatever you would like to ask me.
First of all, Patrycja, thank you very much for this wonderful and very rich and very inclusive talk regarding the doctrine, but also the politics, the challenges, the risks, the roadmap, the inspiration, encouragements for the way forward. So it was really, really full. I can see in the chat that there are questions. We could do a bit of reverse order, in the sense, you know, that there are questions about the special tribunal for the crime of aggression for Ukraine, and there is a fundamental question about its legal basis, you know, about the jurisdiction. And I would like to add here also some concerns, your thinking, your thoughts about concerns regarding legitimacy, you know, the credibility. Maybe we can start with that. And I saw that Gleb, our friend Gleb, has written 2 comments about that. But maybe would you like to start about initially the jurisdiction of the court, how it gains its jurisdiction, and then go into Glenn's question?
Well, the Special Tribunal for the Crime of Aggression against Ukraine, this tribunal is based on the agreement signed between Ukraine and the Council of Europe. And as you could hear, for 2 years, there was a dispute whether we should treat it as an international tribunal or just hybrid tribunal, kind of national tribunal with the international elements. I think that now it could be interpreted, having in mind the letter of the tribunal, that it is international tribunal, that it has its own jurisdiction. It's not relied on the national law of Ukraine as such, but it includes its own definition of the crime of aggression, and it says who should be prosecuted. So I read this statute as the as establishing the new legal basis for the prosecution of the crime of aggression, and I completely accept this, having in mind that, in my opinion, especially in Eastern Europe, we have established customary law concerning prohibition of aggression and possibility to prosecute crime of aggression. So it's not something which is very, we would talk about different regions in the world, we could discuss whether this is imposition of the new standards and retroactive application of the rules. But I think that in the case of this particular aggression, having in mind that you have the crime of aggression in Ukrainian, Russian, Belarusian criminal code, there is no risk that we are acting retroactively by accepting this agreement between the Council of Europe and Ukraine. But also we need to be aware that we are at very early stage, and what is essential now is how many states would sign the agreements on cooperation with this tribunal, because this was also one of the conditions which was stressed by the Netherlands to have really effective instrument and to agree to have the seat of this tribunal in The Hague. So this we will see how those ratifications would go now among other states. And also I see that Gleb is asking, that this definition, which is taken from the RAM statute, and whether this would mean only the application to the events after 2022. Gleb, I would argue that not necessarily, because if we agree, because now we have much more knowledge in comparison to 2014, and I think that now many lawyers would agree that in fact in 2014 we really had aggression, that there is no doubt about this. And having in mind also the judgments of the European Court of Human Rights, which decided that in Eastern Europe, in Eastern Ukraine, we had international armed conflicts, and this was Russia behind those hostilities. We could say that there was aggression ongoing from 2014 with various acts of aggression, and having in mind hostilities in Eastern Ukraine, I would argue that we had this war of aggression already from 2014, 2015. So I would not exclude this possibility, but I agree that this is not very much clarified in the statute, maybe on purpose. Maybe this is just left to judges, but also it's not such a big secret, but Ukraine was asked how many people they would like to see as accused in this court, and they said around 20. Yeah, it's not a huge number, around 20. Yeah, so the issue is on whom they would like to focus, because I think that we could easily count more than 20 people involved in aggression at very high level since 2022, because I count in this number also those who are responsible for the annexation of the territories of Ukraine and for the occupation of the parts of the Ukraine, because I would like to remind you that in the definition of the aggression from 1974, annexation and occupations are listed as separate acts of aggression. Yeah, so that's why I think that the list of the potential accused could be quite a long one. And I do remember one of the lists prepared also by Gleb Bogusz, who also mentioned, for example, the judges of the Constitutional Tribunal and their role in the justification of aggression against Ukraine. And also very good question, this was raised by many lawyers, that aiding and abetting is excluded from the statute. Whether this was mistake or not, I think that this was omission during the negotiations, like also we don't have the statements concerning the command responsibility in the statute and other ways of involvement in the aggression. I think that maybe at the end of the negotiations, negotiators were too much focused on specific people, and they omitted certain provisions. They didn't think about those consequences. But I think that if the number of the accused should be limited, that's why they excluded those who are supposed to be involved in aiding and abetting. But this raises the issue, what about Belarus? What about North Korea? And as far as I know, during the negotiations, the potential accused also from those states were also mentioned. But what was mentioned is that their role is not in aiding and abetting, but this is involvement in their own aggression against Ukraine. So this could be like safety valve to include all those who would potentially we could accuse in this court.
Wow, thank you very much. I can see Elizaveta, who's just started her PhD at the Department of War Studies, is also asking two, I would say, quite interesting question. I don't know if you want 1 minute to read them. One is...
This is Elizaveta, yes? You are
Yes, Elizaveta, about, to what extent actually the amendments were partially...
Elizaveta is asking very good question, and also touches a very important problem, which sometimes is omitted by the international criminal lawyers. It's the way the amendments should enter into force, with what kind of the majority, and there were various possibilities presented, 1 to 1.4, 1 to 1.5, just to let you know that yes, there is an option that the amendment should be adopted with 7/8, quite high majority, but then the result is that this is binding for everyone. However, you can withdraw from the Rome Statute with the immediate effect. Although the majority of the states participating in the special session, they favored rather 1 to 1.5, just to have the quicker effect, so that this expansion maybe would not be for everyone at once, but at least we would move step by step, and with the campaign for the ratification, it would work better. And also we did make some calculations, and if you would apply this 1 to 1.4 and 7/8 majority and these requirements of the ratifications, it would mean in practice that we would have to wait 50 years. And that's why this is very discouraging, that even because we just compare how other amendments, in what pace they were ratified. I already told you during my talk that there was this criticism that amendments on the crime of aggression is ratified only by 49 states now. It's a very low number, so on. But if you look at other amendments to the Rome Statute, you would see that the level of ratifications of all those other amendments is much, much lower. Yeah, and also maybe you remember that in the Rome Statute you have the provision which gives the new state party to exclude the jurisdiction of the ICC for 7 years in relation to the war crimes. And this was already adopted by the Assembly of States Parties to just exclude this provision from the Rome Statute. And this has to, for this we need to have this high number of ratifications, and it's going extremely slowly. So when we compared this pace of the ratifications of various amendments, we know that to insist on this procedure of 7/8, it would mean waiting another 50 years. this explains why, for example, France is so much in favor of this procedure. Yeah, but we need to have this in mind. What would be the results? And yes, indeed. Lizaveta, you are right that some provisions are we should apply to them 1 to 1.4, to some provisions 1 to 1.5, but this problem was already raised in Kampala, and in Kampala it was already decided that we have the definition. We also had the jurisdiction provisions, but we cannot decide to apply two different procedures. So that's why the idea was, no, let's apply only 1 to 1.5. So now when we want to amend those provisions now, one of the arguments was that if we decided in Kampala that, having in mind all those problems, that we have various provisions, and in practice, well, in theory, we should apply two different procedures, yeah, but this would complicate the whole picture. And in Kampala, we decided to apply 1 to 1.5. So now we also should follow this track, that because we need to act in very similar way. But you are right that this, when you read, when you apply Vienna Convention on the Law of Treaties, when you apply the whole amendments provisions of the Rome Statute, it doesn't sound so obvious and logic. You asked whether it was possible to create the tribunal based on the United Nations General Assembly resolution. I would say that if there was such a possibility, definitely Ukraine would go for this solution. But they were aware that it was impossible to build sufficient majority. Just check all the resolutions concerning Ukraine adopted in General Assembly. When you were just adopting the resolution, there was an act of aggression committed in Ukraine, it was quite easy to adopt, to build this majority. But for example, the resolutions concerning register of damage, the register of damages, this was the follow-up of the resolutions, but this decision that we need to document all the losses and register them properly, this was adopted with very little majority, I would say. So Ukraine, of course, was much more willing to have the tribunal established by the United Nations General Assembly, but it was impossible to build sufficient number of votes, and they didn't want to risk the voting in General Assembly, not being certain that they would win this vote. But I fully agree that this would be much better, because this would prove that the war against Ukraine, it's not only regional problem of Europe, but this would really prove that this is a threat to the security in the whole world. And that's why for Ukraine, it was so important to have also non-European states in the core group negotiating the statute. Yeah, and that's why now they are also putting pressure on the states from Latin America that they should ratify the cooperation agreements, to show that this is not only local dispute, but really serious problem for the peace. Hanna Kuczynska, my colleague, is asking about prosecution before national courts, but of other states than the victim. Well, firstly, in case of Poland, we have quite broad definition of the crime of aggression, and it is possible to prosecute aggression committed against another state, even if Poland is not a victim. But overwhelming majority of the definitions of the crime of aggression in national laws, they are focusing only on aggression committed against this specific state, like German criminal code, So this is the first obstacle which I see, that sometimes the criminal law of states is not prepared for the prosecution of the crime of aggression committed against other states. And second thing, you do mention universal jurisdiction, and I think, yes, universal jurisdiction can be used to prosecute crime of aggression. And I think that also sometimes we have some limitations concerning universal jurisdiction. For example, we require the presence of the accused on the territory of the state, and without it, we cannot proceed anymore. But also, I think, and this was tested by Poland, and now it's tested also by other states because it helps them to go further, we also usually have in criminal codes the so-called protective jurisdiction. And Poland, for example, opened its investigation concerning crime of aggression by the justification that crime of aggression against Ukraine is against the world peace and security. It means it's also against the greatest value for Polish state. And that's why we didn't open the investigation concerning crime of aggression based on universal jurisdiction, but based on the protective jurisdiction. But I would mention Hanna Kuczyńska once again, because I remember that Hanna had a very tough discussions with the prosecutors who have very cautious approach that, well, we do collect evidence, but we are just supporting Ukrainian courts, that our investigations is just of supportive character. And then Hanna with other colleagues had to explain, I'm sorry, but if you start the investigation based on protective jurisdiction, this is your own investigation. It's not to support another state, but you need to go and investigate it on your own, not counting on Ukrainian tribunals. So, but I think that your question is very important, because I think that states should be encouraged to treat crime of aggression as any other international crime, and should really test the possibilities to investigate, to prosecute this crime in their own national tribunals. If we are convinced, and I'm pretty sure that we are convinced, that crime of aggression is one or even the most serious crime in international criminal law.
Patrycja, thank you so much. I know we started late. I know you speak for 1 hour. You respond to all the questions. We can see your passion. Everybody thanks you. I thank you. I have a final question, if that's okay with you.
Of course.
And today I was talking about that a little bit in my class and the other day. So you mentioned, about human rights. So we have the General Comment 36 about the right to life. We have the famous paragraph 70, that what could be considered an arbitrary loss of life, that the loss of life due to an aggressive war is an ipso facto an arbitrary loss of life. And we know that now before the Human Rights Committee, apparently there is an application of Ukrainians on making that claim before the Human Rights Committee, which is not the tribunals, is a quasi, as we say, judicial organ. And I would like your thoughts about that, because there are two different positions. There is this position, which is like, yes, we have the humanization of jus ad bellum, and there is this other position which is a little bit more cautious and says, okay, it goes back to IHL, a belligerent equality, and also issues are the Human Rights Tribunal capable of dealing also, with the jus ad bellum and with determinations of aggressive wars? And is that where we should go? Should they be more careful about that? So just some thoughts, I know the situation is more nuanced, but because you're the expert on aggression, and I found this particular provision so interesting about that, and how it affects other fields of international law and possibilities, like about tribunals, about remedies based on human rights laws. I was wondering your final thoughts about that. Thank you.
Yeah, this is extremely important question, and which was particularly raised from 2022. Yeah, that we have this human rights impact more and more. Yeah, and of course, on the one side, I see one of the concern is that if, according to IHL, you have some lawful targets which you can attack, and suddenly because of human rights, you would say, no, every destruction and every killing is unlawful, then if everything is prohibited, this would mean that there would be no prohibition at all, because then we would not care about any rules. However, I think that we also need to think in non-standard way, that one thing is to speak about the responsibility for war crimes, and then concerning war crimes, I would say that we could not prosecute as a war crime killing of enemy soldier who is taking part in hostilities. Yeah, because this would be like against the definition of war crimes as such, because the war crimes are defined as the different kinds of abuses against protected persons and objects according to Geneva Conventions and additional protocols. So they refer to ICL instruments, but this is the responsibility, individual responsibility for war crimes. However, another story is the state responsibility. And here there is an argument that, okay, we will not prosecute people for killing soldiers, but we want to have reparations for the crime of aggression, so for all the kinds of losses. And this was the approach adopted by the members of the Register of Damages, because what they do, they register all kinds of damages. They don't, check whether this building was destroyed lawfully or unlawfully in light of ICL, but they just register everything. And I think this is quite the interesting development, because also we need to remember that Register of Damages, this is the first step. The second step, this is the Claims Commission, which will be established in the middle of December. There is this ceremony of signing the Treaty on Claims Commission. And then the third step would be the real arrangements concerning payments. Yeah. So we will see whether during those two further steps, this human rights approach will be really respected. However, I think that this human rights impact is another dimension which would be an incentive to really respect prohibition on use of force. Yeah. So at first I was very, cautious, and I said, no, this is just against what I know from ICL. But then I tried to figure out that, okay, but maybe we should make a clear distinction between what we expect from those who fight, from people, and what we expect from the state as such.
Wow. Thank you so very much. That was truly, truly rich. And I think it brought very nicely together the doctrine and the politics, right? The law and the politics. And you highlighted, also you gave insights about the negotiations, how you had to finish by 6 p.m., or stuff like that, a kind of pressure, which is a very interesting insight about what's going on in fora, in diplomatic fora. Patrycja, I would like to thank you once more very much. Many, many thanks about that. Thank you on behalf of all the participants. It was really, really rich. And hopefully we will be able to host you in person next time in London, and to see you in person, because definitely there are so many developments. And we live in an era where everything goes, as we can see. But I want to thank you on a personal note also for giving a non-damned, gloomy perspective. There is a perspective that things are done. Some things don't happen, some other things happen, but that doesn't mean that we shouldn't try. We shouldn't keep trying.
Of course.
Thank you very much. Thank you all for participating, for asking the questions. Many thanks to you, Patrycja. Apologies for my lack of technological skills, but thankfully it all worked very well. Thank you very much, and hopefully we'll see each other soon. Thank you, and bye-bye, everyone. Bye-bye. Bye, Kleb. Very nice seeing you. Bye-bye, everyone. Thank you. Ciao, ciao.